Hey everyone, this is Mr. US History. Welcome to a brand new video. In this video, we're going to go through each era of the Supreme Court, starting with the Jay Court and ending with the Rehnquist Court. We're not going to go over the Roberts Court because that is the most recent era of the Supreme Court. It is the Supreme Court now, and because of recency bias, as well as the fact that it literally is still going on right now and deciding cases, would make it unfair to rank it. So that's a court we're excluding, and we're going to start with the Jay Court. So when I mean each Chief Justice and each era of the court, I'm not ranking the Chief Justices, but I'm simply ranking each era of the Supreme Court under each Chief Justice. So I'm effectively ranking the majority because in the Supreme Court, it is the majority that decides each of these decisions. So I'm ranking the majority effectively of each of these Supreme Courts, but I'm simply putting the Chief Justices because it happened under these Chief Justices. So anyway, let's get started with the Jay Court, which begins with John Jay. So I'm going to give the Jay Court a B. This was before the era of judicial review, and one could argue that the Jay Court had an opportunity to establish judicial review but didn't do so, which would be accurate. However, the Jay Court was still important because it set up most of the institutional precedents for the Supreme Court. For example, the independence of the Supreme Court was established under the Jay Court. For example, George Washington, he tried asking John Jay for constitutional advice, but John Jay would consistently reject to offer. While this may seem like a bad thing at first, keep in mind this set up the Supreme Court as independent from the executive office, which is a really good thing for the court. So in terms of its impact on the court, the Jay Court would definitely be impactful. However, it lacked any impact on people whatsoever in America aside from just affirming the legacy of a Supreme Court as an independent branch of government. So that's why the Jay Court gets a B. Next up is the Rutledge Court. The Rutledge Court doesn't even really count as an era of the Supreme Court because Chief Justice John Rutledge wasn't even confirmed by the Senate. He was a recessed appointee, but the Senate rejected him because of alcohol abuse. So because of that, he goes in the not available or NA tier. Next up is the Ellsworth Court. The Ellsworth Court gets a C. It didn't really do anything significant, no judicial review, just kind of continued setting up most of the institutional precedents that the Jay Court had already started. But again, most of those precedents were already established in the Jay Court. So that's why it only gets a C. Next up is the Marshall Court. The Marshall Court undoubtedly gets an A. The reason why is because of Marbury v. Madison, which effectively established the Supreme Court as an independent branch of government with power. The Jay Court already established the court's independence, but it didn't really have any power. But the Marshall Court gave it power through Marbury v. Madison, which established judicial review. Because of this, the Supreme Court now can strike down federal and state laws that are unconstitutional, which makes it exceptionally powerful. So, just because of its impact on the Supreme Court and creating it effectively as the institution it is today, the Marshall Court gets an A. Now, the reason why the Marshall Court and no other court for that reason gets an S is because the Marshall Court was very judicially activist. What I mean by this is the Marshall Court was trying to be a little bit too partisan, and it was trying to influence policy more so than it was trying to review it, which is the main job of the Supreme Court. Under the Marshall Court was very pro-federalist, and in many cases it was a partisan institution of the government, and the Supreme Court is not meant to do so. In Gibbons v. Ogden, as well as McCulloch v. Maryland, and multiple other cases, the Marshall Court repeatedly established the federal government over the state government and was really the only branch of the Federalists left at all after the party effectively ceased to exist. The Marshall Court also affirmed the interest of corporations multiple times with Fletcher v. Peck and Dartmouth College v. Woodworth. Both decisions made it difficult for states to regulate the activity of corporations, thus paving a way for the unrestricted action of corporations in this early era of corporations in America. So, because of some flawed decisions as well as too much judicial activism and federalist bias, the Marshall Court gets an A and not an S. So next up is the Taney Court. The Taney Court undoubtedly gets an F. Dred Scott v. Sanford was an awful case, which effectively relegated the status of African Americans as property rather than citizens, and this wasn't the only case that did so. For example, the Taney Court throughout its existence consistently affirmed the power of the states over the federal government unless it conflicted with slavery. For example, in Ableman v. Booth, the Taney Court ruled against the state because it tried to go against the Fugitive Slave Act. And in this time, it ruled in favor of the federal government in trying to implement the Fugitive Slave Act. So as a whole, the Taney Court was in favor of states' rights only when those states' rights did not conflict with slavery. And most members of the Taney Court were actually slave owners, so this would make sense why many of them ruled in favor of protecting slavery. But overall, the Taney Court has the legacy as the worst era of the Supreme Court because of its role in protecting slavery. So that's why this gets an F. Next up is the Chase Court. The Chase Court gets a B for me. The decision Texas v. White was very important in ruling that secession was unconstitutional, and VZ Bank versus Fenno allowed the federal government to finance itself during the Civil War because it ruled measures such as the National Bank as well as paperbacks and printing money as constitutional. So because of its positive impact during the Civil Court, as well as its rejection of secession, the Chase Court gets a B. Next up is the Waite Court. The Waite Court had a lot of potential. In fact, the Chief Justice Morrison Waite was appointed by Ulysses S. Grant, who was in favor of Reconstruction and the 1860s version of civil rights. However, Morrison Waite and his Supreme Court ultimately get a D. The Waite Court was awful. It was not as bad as the Taney Court and the court that's going to come after, but it was still really bad. Minor v. Happersett ruled that women do not have equal protection under the 14th Amendment, and the civil rights cases of 1883 further limited the scope of the 1866 Civil Rights Act, which meant to protect African Americans in the South. United States versus Cruikshank also limited the scope of the judiciary or the of the United States Department of Justice, or DOJ, in prosecuting civil rights cases as well as hate crimes against African Americans. So because of United States v. Cruikshank, the amount of hate crimes in the South increased, and Santa Clara Company versus Southern Pacific Railroad was also a case in which it ruled that corporations were effectively people when it came towards the ability to restrict them. And this would pave the way almost 150 years later with Citizens United versus FEC. So overall, the Waite Court, I think, was a pretty bad era in Supreme Court history because of its restrictions on civil rights as well as its decisions in favor of corporations. And continuing this legacy is the Fuller Court, which was even worse than the Waite Court. The Fuller Court gets an F along with the Taney Court. The Fuller Court was very problematic regarding civil rights as well as corporations. The Fuller Court ruled in favor of corporations time and time again, such as in Lochner v. New York when they ruled against a minimum wage law or 8-hour workday law by the state of New York, arguing that it violated the right of contract or part of the 14th Amendment. It used this very broadly, and also the Fuller Court was willing to use the 14th Amendment to restrict the power of states to regulate corporations. However, they were completely unwilling to use the 14th Amendment to use what it was actually intended to do, which was protect the rights of African Americans. And we saw this right with Plessy versus Ferguson, where the Fuller Court ruled against African Americans in the South and paved the way for segregation for almost 100 years through the separate but equal doctrine. And also, Che Chan-ping versus United States ruled in favor of Chinese exclusion. So the Fuller Court was completely in favor of the 14th Amendment when it came to protecting corporations, but was completely against the 14th Amendment when it came towards equal rights. The Fuller Court also ruled in the United States versus E.C. Knight Corporation against an antitrust law, viewing it as unconstitutional. And in Adair versus United States, the Fuller Court ruled in favor of corporations once again by banning restrictions on yellow dog contracts. And yellow dog contracts were effectively contracts that limited the power of labor unions, and when states tried to ban these yellow dog contracts, the Fuller Court ruled those bans as unconstitutional, thus allowing employers to prevent their workers from joining unions, which were protection for many of these workers in such an era of wage abuses where workers were not getting paid. And then there were also the insular cases in which the Fuller Court ruled that that people living in the territories recently acquired by the United States were not citizens, thus paving the way for decades of discrimination. So overall, the Fuller Court has a very bad history and very bad reputation regarding civil rights as well as corporations and protecting them from restriction as well as accountability. So the Fuller Court undoubtedly gets an F. Next up is the White Court. The White Court, I think, is better than the Waite Court, but it still was not overall a great era in Supreme Court history. I'm going to give it a C because there was some progress, but it was still largely a very reactionary court like the Fuller Court was, but it wasn't nearly as bad. For example, there were some bad cases, such as Hammer v. Dagenhart, which ruled against a child labor law which the United States government passed. The child labor law would prevent corporations from implementing and using child labor. However, the White Court struck this down as unconstitutional, which was a bad decision. And then there was also the Bunting v. Oregon case, which further continued Adair versus United States. It reaffirmed this and basically continued restrictions on labor union activity as a result of this. And then there was also Copage v. Kansas, which again was very similar. And then Schenck versus United States, as well as Abrams versus United States, which were two terrible cases that ruled in favor of the Espionage and Sedition Acts, which were unconstitutional violations of the First Amendment. So as we can see, the White Court overall is very similar to the Fuller Court. However, there was some progress. For example, in Standard Oil Company versus New Jersey, the White Court effectively ruled in favor of the federal government in restricting the activity of trusts and allowed for Standard Oil to ultimately be broken up. And then there was also Gwynn versus United States, which ruled that the Grandfather Clause of Oklahoma was unconstitutional because it discriminated against black voters. So overall, the White Court wasn't really that great. It would get a D, but because of Gwynn versus United States, that's why it ultimately gets a C. It wasn't nearly as disastrous as the Fuller Court in terms of what its decisions did and its impact, and it had a few redeeming qualities. And overall, even though it was largely reactionary, there was some progress and there was some movement in the right direction. Next up, we have the Taft Court. The Taft Court is going to get a C. The Taft Court's actual decisions were pretty awful. Buck versus Bell ruled in favor of a Virginia law that would do sterilization of individuals with Down syndrome. And then there was also Adkins v. Children's Hospital, which continued the Lochner tradition of using substantive due process. And then there was also Lum versus Rice, which ruled against Chinese children who wanted to go to the same school as white children in the state of Mississippi. So overall, it was almost as bad as the Fuller Court, I'd say, in terms of its decisions. It was certainly worse than the White Court in terms of the decisions, though I wouldn't say it was as disastrous as the Fuller Court in terms of setting up a legacy of substantive due process to protect corporations as well as separate but equal. So the Taft Court would be getting a D. However, because of the institutional changes enacted under the Taft Court, that's why it gets a C. For example, the justices of the Taft Court pursued the Judiciary Act of 1925, which allowed for the Supreme Court to get its own building and also expanded the concept of discretionary review, thus allowing the court to choose its own docket. The Chief Justice also became the head of the entire judiciary of the United States, and there was a judicial conference established where judges could meet to coordinate administration, and the court no longer relied on the DOJ for funding, which further gave it independence from the executive branch. So as a whole, the Taft Court was pretty bad when it came towards making decisions, but because of the institutional changes and overall positive impact of the Supreme Court that came, largely because of the justices' own interest, is why the Taft Court gets a C rather than a D. So next up, we have the Hughes Court. So the Hughes Court initially started very similarly to the previous courts, such as Taft, Fuller, and White. Moorhead versus New York and United States versus Butler both continued the Lochner tradition of going against progress and effectively casting down state as well as federal laws as unconstitutional because of substantive due process in the 14th Amendment, as well as just not viewing them as within the scope of Congress's power. However, this would ultimately change with West Coast Hotel v. Parrish, which was later known as the switch in time that saved 9, which ended the Lochner era and affirmed a New York law that put regulations on corporations. Also, United States versus Darby Lumber Corporation effectively allowed for New Deal programs to remain in place. So overall, the Hughes Court was a movement in the right direction. Although it started off poorly, I'd say it got off to the right track later on. So that's why I'd give it a C, because it largely affirmed many of these New Deal programs that would be instrumental later down the stage. But early on, it was very bad in terms of rejecting these New Deal programs that in many ways helped a lot of people. However, even after the switch in time that saved 9, the Hughes Court was still not that great. There was a decision such as Minersville School District v. Gobitz, which restricted the ability of Jehovah's Witnesses. So overall, I'd say the Hughes Court gets a C, because it was not perfect, but it was a movement in the right direction. So next up, we have the Stone Court. This was a pretty brief era of Supreme Court history, but I'd say it was pretty significant. I'd give it a C. It would get a B if not for one decision, which I'll get to later. But Wickard v. Fillerburn and multiple other decisions allowed for the federal government to continue enacting these New Deal programs, which were helpful during the end of the Great Depression, as well as to finance the government during World War II. But this court was by no means perfect, especially because of Korematsu versus United States, which ruled in favor of Japanese internment camps and upheld the constitutionality of them. Korematsu is viewed as one of the worst decisions in Supreme Court history, and because of that, the Stone Court, which would normally get a B because of its affirmation of New Deal programs, is going to get a C instead, just because of that one decision. And the Stone Court also reversed the Hughes Court decision of Minersville School District v. Gobetz, ruling in favor of Jehovah's Witnesses in West Virginia State of Board of Education versus Barnett, which allowed students to decide whether or not they want to say the Pledge of Allegiance if it violates with their religion. So that was a good decision in terms of affirming religious freedom. So that's why the Stone Court gets a C instead of a D, which it would normally get because of Korematsu. So next up is the Vinson Court. The Vinson Court is going to get a B from me. It largely continued the progressive trend that was starting with the Stone Court, minus Korematsu, of course. There was McCollum versus Board of Education, Dennis versus United States, and Sweat versus Painter, which were all pretty solid decisions for the most part. So let's start with Sweat versus Painter. This was a decision that challenged the separate but equal doctrine. It didn't fully get rid of it, but it set the framework for Brown versus Board of Education. And then there was also Dennis versus United States. This was also a pretty good decision, I'd say, for the most part. In Dennis versus United States, it upheld the conviction of 11 leaders of the American Communist Party, and because of threats to national security. So this was overall a good idea, even though you may argue that it restricted freedom of speech. These individuals were still planning to violently overthrow the United States government, so I'd say this was a good decision. And then in McCollum versus Board of Education, the Vinson Court further continued religious freedom by stating that there has to be a separation of church and state with regards to education, and public schools cannot push Christianity or any kind of religion. So overall, the Vinson Court, I'd say, was pretty much moving in the right direction, but it didn't quite get there of the Warren Court, which I'm going to get into now. The Warren Court gets an A from me. The Warren Court was absolutely instrumental in setting up many of the rights which Americans take for granted today. Take, for instance, Brown versus Board of Education, which got rid of the separate but equal doctrine and allowed for integration in public schools. This was a massive case and a fundamentally good decision, as well as Loving v. Virginia, which ruled in favor of interracial marriages, and Engel v. Vitale, which allowed for further religious freedom in public schools by not allowing public schools to have prayers, which would effectively push one religion one way or another. And then, of course, Miranda versus Arizona, which is the reason why there are Miranda laws today. And Miranda basically gave more rights to defendants. There was also Gideon v. Wainwright, which allowed for defendants who are being prosecuted to have the right to a lawyer even if they don't have the money for a lawyer, and Reynolds v. Sims, which introduced the idea of one person, one vote with regards to redistricting. So overall, the Warren Court is a big reason why many Americans have rights today that they take for granted. But this court was still not perfect overall. Much like the Marshall Court, it was very judicially activist in terms of trying to push legislation themselves and trying to create laws rather than review laws. But keep in mind, almost every Supreme Court on this list has been like this. Even the more conservative courts like the Fuller Court were still extremely judicially activist in terms of trying to make their own laws instead of reviewing laws. But overall, just because of positive impact, the Warren Court gets an A. So next up is the Burger Court. The Burger Court, I'd give the Burger Court a B. Chief Justice Warren Burger was not really that great of a person. He was extremely homophobic. But the court under him, I'd say, as a whole, in terms of decisions made, were pretty solid because, again, I'm not ranking Chief Justices. I'm ranking the eras of the court which they presided under. So there was United States versus Nixon, which ruled against Richard Nixon, despite the fact that he appointed many members of this court. They ruled against him and said that as the president, he is not above the law. This was a great decision. There was also New York Times versus United States, which ruled in favor of whistleblowers as well as bringing accountability. And there were still some conservative decisions, though, like Gregg versus Georgia, which ruled in favor of the death penalty, as well as United States versus Leon, which restricted the rights of defendants and allowed for police to find evidence illegally if they did so with good reason or good faith. And there were some controversial decisions such as Roe versus Wade, which I'm not really going to get into, mostly because of how recent and how that it is. But overall, the Burger Court was largely continuing the same tradition of the Warren Court and mostly upheld a lot of their decisions, but it was a little bit more conservative and kind of scaled back some of its decisions, particularly regarding criminal defense and civil rights. So that's why I'd give the Burger Court a B instead of an A, and it didn't create this like the Warren Court did. So next up is the Rehnquist Court. The Rehnquist Court gets a C from me. It had some pretty bad decisions such as Bush versus Gore, Shaw versus Reno, and Viet versus Jubileer. So let's get into this. Bush v. Gore was a pretty bad decision. I think this was a very partisan decision by the court. It applied the Equal Protection Clause in a very broad way, which most courts would not use to stop a recount, and the recount absolutely should have happened. It's not because of the outcome, which was Bush winning the election, but simply the way in which this decision was implemented, which was extremely partisan. And then there was also Viet versus Jubileer, I believe, which affirmed Viet versus Jubileer affirmed partisan gerrymandering as constitutional, stating that there was really nothing unconstitutional about partisan gerrymandering. And this is the reason why partisan gerrymandering, especially now, is such a big problem because of this decision, which affirmed the constitutionality of it. And Shaw versus Reno, which limited the scope of what would be considered racial gerrymandering. So these were three bad decisions, but there were also some good decisions by the Rehnquist Court as well, such as Texas v. Johnson, which was a win for free speech, as well as Lawrence versus Texas, which allowed for same-sex relations to be there, so to speak, and ruled against restrictions on what was considered then as sodomy, but is effectively freedom of choice and freedom to be with whoever you want. It didn't quite go in the direction of legalizing same-sex marriage, but it was definitely a movement in the right direction in terms of allowing freedom to be with who you want. And then there was also Dickerson versus United States. Dickerson versus United States was a pretty good decision, I'd say, for the most part, because it affirmed Miranda versus United States. And this was pretty ironic because Rehnquist was one of the biggest opponents of Miranda when it was decided, but in this case, he ruled in favor of Miranda. And then there was Planned Parenthood versus Casey, which affirmed Roe versus Wade, which I'm not really going to get into. But overall, the Rehnquist Court has a very mixed legacy, so that's why I'd say it goes in the C tier. Some bad decisions, some good. So that's why it goes in the C tier. So there we go. That's our tier. That's my tier, at least, of every Supreme Court era in United States history. I hope you like this video. I hope you comment in the description what you would change, what you agree with. And make sure to like and subscribe. Mr. U.S. History, out.